Okay, well, welcome everybody to the Autism Society of Greater Phoenix's, our online support group. We want to welcome tonight Stephanie Bivens from Bivens and Associates. She's going to be talking tonight about guardianship and special needs planning. So we're going to go ahead and record this as well. So if you need to come back to it, you're definitely able to. So Stephanie, I'm going to go ahead and hand it off to you. I'm going to go ahead and mute myself. And you can go ahead and proceed. And like I said, I will definitely help you out with any chats that come through.
Oh, yeah, perfect. So, well, hello, everybody. Thanks for joining us. Our topic is guardianship, special needs planning, basically estate planning for families who have special needs loved ones. But we can go off topic also, answer the questions. I'm really here to participate, to be a resource for you tonight. So a little bit about me, for those of you who don't know me, I am an attorney. I've been in practice for 25 years. I'm also a Phoenix native, so I've been in practice in Arizona this whole time. And my practice area consists of estate planning, probate, trust administration, elder law, and special needs planning. I am a certified elder law attorney by the National Elder Law Foundation, and there's myself and a number of other attorneys with the firm. My firm is Bivens and Associates. There's myself and 4 other attorneys right now. And so there's kind of a list here of everything that we do. But with regard to special needs planning, that's really going to encompass an understanding of public benefits, including SSI, SSD, Medicare, Medicaid, HUD, SNAP, all text, all the government benefits acronyms that you can think of, we're going to be very familiar with. Special needs trust administration, the drafting of all of the various types of special needs trust, and we're going to be talking about those some tonight. We also do a lot of guardianship and conservatorship. So a lot of what we do is working with families, whether it's parents, grandparents, or other relatives who have a loved one with a special need or a disability, to make sure that there's the right planning in place and that all the right legal documents are going to be set in advance so that the family can take care of this person as best possible with long-range planning in mind. So we're going to talk tonight a little bit about guardianship first, the different types of guardianships, when you might want a guardianship, when you might not want one, a little bit about conservatorship, and then we'll talk about estate planning for special needs individuals, and particularly the use of special needs trusts. So just so you know, that'll kind of be the order that we'll go through. So the first question is, who needs a guardian? So when you are the parent of a minor child, you get to make your under age 18 child's personal and medical decisions just because you're mom and dad. But when that child reaches the age of 18, legally, they are an adult, and mom and dad or others no longer have the default personal and medical decision making, because that falls to the individual once they hit the age of 18 and over. So when you have a situation where you have an adult who is incapacitated, which just simply means they are not able to make reasonable and rational decisions concerning their own personal needs, whether that's medical decision making, educational choices, living arrangements, or other types of personal decisions. If they are incapacitated, then we may need a guardian for that person. The other circumstance in which we will see the need for a guardian is when the individual becomes incapacitated and they don't have a valid healthcare power of attorney or mental health power of attorney designating that person. So oftentimes we'll see situations where someone has a developmental disability, they age up, now they are an adult. If they are not able to understand and sign a healthcare power of attorney that would designate a parent or another relative or friend to make medical decisions, if they cannot, and later they couldn't, we might need guardianship. Or if they age up, they hit the age of majority, which is 18 here in Arizona, and they are not able to make their own medical decisions, we're probably going to want to think about guardianship for that person. The person who becomes the guardian has all of the authority a parent has over their minor child. That's literally what the statute says. In order for the court to find an adult is incapacitated, the statute, which I have here up on the screen, says that the court has to find that the individual lacks sufficient understanding or capacity to make or communicate responsible decisions concerning their person. So that's what the court is looking for, is to what degree is this individual able to make their own decisions versus they're not able to make or communicate their own decisions. So who decides if the person is incapacitated? That is a court. When I'm using the term legal guardian, that means it's a court proceeding, and a judge has made that decision based on the supporting evidence of a doctor, an RN, or a psychologist who treats the patient and fills out reports and testifies if they're in court. Otherwise, the court will just rely on the written statement of the medical treating professional, and then the family who gives information. But the court is the party, or the judge is the party that makes the actual determination based on the supporting evidence from the medical professionals. So when we talk about guardianship, there's a number of different types of guardianship, and there's different timing for guardianship. So I'm going to kind of run you through this a little bit. And if anybody's got questions, throw them in the chat, because we'll answer questions as we go. The first type of guardianship is what we'll call a temporary or emergency. Normally, when we talk about guardianship, we call it a permanent guardianship. And you'll file a request to be appointed as a permanent guardian, but we're not going to get a hearing for the court for a couple of months, usually 6 to 8 weeks. Well, when we have an emergency situation, meaning the person who's in immediate risk of irreparable physical injury or harm, maybe they need medical treatment, they're refusing, maybe, the family is at odds about what medical treatment, maybe they're refusing life-saving medical treatment. There could be very high stakes situations in which we don't have 6 to 8 weeks to wait before the regular hearing date on a permanent. So we go in on an emergency, or what's called a temporary. Typically, the temporary or emergency just means we're in very quickly, within days of filing the emergency request. And the authority granted is full authority. It's just temporary until we have time for the permanent hearing. So it's our stopgap measure. Oftentimes we'll see these when somebody needs emergency medical treatment and it's life-saving, or they had to be admitted for inpatient psychiatric facility treatment under the surrogate decision maker, and we have to file within 48 hours to keep them there. So those are kind of the typical examples. There is what we call a general guardianships, and this is all under Title 14 of our statute. So you'll hear lawyers call these Title 14 guardianships. That's why we call it that. It's a section of our statutes, 14. A general guardianship means the guardian is going to have full authority, full decision-making over their ward or their protected person. And so that means they can decide everything: living arrangements, employment, medical decision-making, educational decisions, anything associated with the personal well-being or the medical treatment for the incapacitated adult. That's full guardianship. Everything except inpatient psychiatric facility treatment. We'll talk about that in a moment. There is also what we call limited guardianship. And we usually see these in cases where we have young adults who perhaps have aged up. They're 18 years old now, and they're really not emotionally mature enough because they might have some emotional delay in their development. They may not be ready yet to be making all of their own personal decisions. And they might need support or assistance, let's say for medical decision making, to be given informed consent for complex medical treatment. But maybe they're perfectly able and willing to make decisions regarding their education, right? So if we don't want to have full authority and we want to carve out some legal authority for the person to be able to make their own decisions in certain areas of their life where they're able, we would call that a limited guardianship. The court always wants to appoint a guardian with the least restrictive arrangement possible, which means if this individual still wants to vote or may be able to drive, we have to call it a limited guardianship and have the court make a finding that this person is capable of voting and interested in voting. And certainly with these big election years, we are seeing this more and more. Or maybe they want to be able to drive. And of course, MVD has to issue them a valid driver's license. But in order for them to still be able to retain or obtain a driver's license when they're ready, we would call it a limited guardianship. Or if we just want to facilitate, we only need medical and we're going to leave everything else open to them to decide, living arrangements, education. So every guardianship is going to be handcrafted to suit the needs of the individual in the least restrictive means possible. And then the last option here is if the individual who's the subject of the guardianship needs inpatient psychiatric hospital level or facility treatment, or it's clinically foreseeable they will need it within the next calendar year based on their prior history and clinical psychiatric needs, then the court can add onto the traditional Title 14 guardianship this extra authority calling in and say the order and the letters will say Title 14 guardianship with inpatient mental health authority. That means the guardian, if you have that extra inpatient mental health authority added, the guardian will be able to place, admit on an as needed basis every year, and it has to be renewed every year with that court, that added inpatient mental health treatment authority for inpatient psychiatric treatment. Without that, the guardian still has all the authority to consent to outpatient psychiatric care and treatment. So often persons with a developmental disability, or on the autism spectrum, may have a psychiatrist and have some psychiatric meds or therapies or therapeutic, treatment recommended. Guardian can consent to all of that. This is just for inpatient psychiatric hospital level treatment. You need that added authority. And sometimes we need it because we're in crisis at the beginning, and then this individual's under guardianship, their needs are being, managed, their medications, their therapies, treatments are all being managed, and they become very, very stable. And at a certain point, we're going to drop that inpatient mental health authority because the doctor doesn't see a clinical foreseeable need for it in the next 12 months. So you can see guardianship is really flexible. The term permanent guardianship is a little unsavory to a lot of parents, because as parents, of course, we will always want to facilitate the maximum independence of our children possible. So it's only permanent because it's only in place until it's needed. One of the best things I get to do as a lawyer and our judges enjoy is terminating a guardianship. If somebody is later able, they've matured up, or their medical situation has improved, or for whatever reason, they no longer need a legal guardian appointed by the court, we can always petition the court to terminate the guardianship. You get out the same way you get in. So we just have medical documentation that says they can now make all their personal medical decisions, and we don't need this court arrangement any longer. And that usually makes families feel a lot better about entering the arrangement, particularly when somebody's only 18 or 19 years old. When they hit their late 20s, their middle 30s, they may be very different, and they may be better able to handle big decisions because they have more life experience, behind them, and maybe they just took a little longer to emotionally mature. Guardianship is when we talk about personal medical decision making. Conservatorship is when we talk about somebody needing the authority to manage the income and the assets of an adult who is not able to themselves. So in a lot of cases, when we have someone with a developmental disability who is not able to work, and they age up to like age 18, and they're really not able to work, and maybe they're getting SSI or dependent adult child, SSD benefits, you can manage somebody's Social Security as the representative payee appointed and confirmed by the Social Security Administration. Conservatorship doesn't grant authority over Social Security benefits. That's something Social Security does through their representative payee. I'm using legal air quotes, representative payee designation. So really, we only need conservatorship when somebody has income outside of Social Security, maybe wage income or other sources, or they've got a lot of bank accounts, assets, real estate in their own name. So oftentimes, kiddos, I call my kids kiddos. So when the kiddos grow up and they hit 18, they usually don't have a lot of money in the bank. But we will see conservatorship necessary when maybe that individual is receiving a lawsuit settlement and they're going to come into a sum of money, or perhaps an inheritance, and we'll talk about the ways to structure that later. Or maybe they were able to work and amassed something and then are unable, and they didn't have a financial power of attorney in place, and we need conservatorship. The types of conservatorship, again, emergency or temporary appointment. If we're going to have irreparable injury, loss, or financial harm without that being put into place immediately by the court. General, it's all the authority granted by state law under the conservatorship statute. But you can also go in if you just need to do one or two things. You can also go in under what's called a limited or single transaction request, or there's something even called a protective arrangement, which is slightly different. And sometimes we will create trusts by court order and enter into a protective arrangement. So how we manage somebody's assets through a court order, again, there's a lot of flexibility there. Typically, you will see it called a conservatorship. So who's going to get appointed, right? Who's the court going to pick? Well, the court has to make a determination as to who the judge thinks will serve the best interests of the person under guardianship and conservatorship. And the court, by statute, is given a list of persons to consider to be given priority for appointment. So if a guardian or conservator has ever been appointed in another state, Arizona is going to give priority to that person or those individuals. If the person who's going to be the subject of guardianship or conservatorship is able to express a preference, then the court needs to take into consideration the persons that they prefer and would want. If they had done a power of attorney while capable, and for some reason we're still needing guardianship or conservatorship through a court order, the person's designated in the power of attorney. And then if we don't have any of that, a spouse, if they're not married, an adult child, no adult children, then a parent. So in a lot of these younger cases, somebody's now turning 18, 19, it's going to be the parent will have priority, or any other relative with whom they've resided for more than 6 months. So, there's a lot of grand families out there. So if a grandchild who has a developmental disability who needs a guardianship has been residing with a grandparent, and the grandparent is essentially the custodial or the de facto guardian, grandparent may have priority over parent in that circumstance. And then the statute goes on to list more people, but usually these are the most common scenarios. Guardianship is going to be necessary when the incapacitated person refuses appropriate health care, medical assistance, either with or without a healthcare power of attorney. We'll see that oftentimes if they have dementia, brain injury, significant developmental disability. If the agent or the surrogate decision maker, the default person, is acting inappropriately. Sometimes we see cases like that where we just have bad decision makers under powers of attorney or default law. We need to set them aside and get a good decision maker in place. So oftentimes family conflict will create that and we'll go to court. If there's disputes between people who have equal priority, equal co-agents, or equal surrogate decision makers, or there's third parties that are creating problems. And oftentimes with a developmentally disabled population, I will see kids turn 18, 19, and the parents don't have any issue with the child. The child is not making poor decisions or disrupting their own care. And the caregivers or the medical doctors are even, relying on the parents as the surrogate decision makers. And we're not having issues for the medical, but it's the public benefits side. It's dealing with the DDD caseworker, is dealing with the Altex caseworker, it's dealing with the IEP at school. And it's the system is putting up roadblocks and not wanting to talk to the parent because the system isn't supposed to talk to the parent. Remember, the parent now has a child that is a legal adult. So oftentimes these younger cases, in order for the parent to effectively be the advocate and deal with all the public benefits and educational professionals, we end up with guardianship, just so nobody questions their authority to share information and be the advocate. The process, you can file a petition for someone as young as 17 and a half. So we don't have to be at court on the 18th birthday. I've been doing this for 25 years. And so probably 10 years ago, the statute was changed, but I spent a lot of 18th birthdays with families at court. That's not a good way to spend your 18th birthday. So what's really nice is to plan ahead, file it early, have the hearing early, and the court order will say effective on the 18th birthday, this person is now the legal guardian. So it's a really good way to not have a time crunch and get things worked out with the family ahead of time. Once the petition is filed, notice has to be given by law, which includes personal service to the person subject to the guardianship. It's required by statute. We don't get to waive it. A process server will show up at their school or at the house, wherever we coordinate that, and that will happen. You can be there. We usually coordinate when a family member will be there, so it's not such a startling event if that would be upsetting to the individual. An attorney will be appointed by the court to represent the alleged incapacitated person. That lawyer's job is not to tell the court what is best or in the best interest. That lawyer's job is to advocate what the proposed protected person would want. So if you file for guardianship over somebody who says, I hate this idea, nothing's wrong with me, I can make all my decisions, or I don't want you, the lawyer is going to tell the court that and contest the proceeding. They don't have an option. There will be a court investigator. That is an employee of the court. They are tasked with interviewing everybody, looking at the totality of the circumstances, and writing a report for the judge to consider as to what is in the best interest of the proposed protected person. There will be a hearing. The commissioner is going to hear from both sides. They're going to review the medical evidence, medical records, and then sometimes at that hearing, the court's ready to make a decision. Sometimes they'll take it under advisement. If there's no objection, usually they sign the court order and the letters get issued that day. The order appoints the guardian, but it's a document called letters of appointment that is what actually shows you have the authority to act. So it's the letters issued by the clerk's office that go to the school, the doctor, the hospital, anybody that you're dealing with on behalf of the child. And then every year, as the guardian, you have to fill out a guardian report, and a physician who is treating the protected person or the ward, we use different terminology for that, has to fill out an updated health professionals report. You don't go back to court, you just send it into the court and file it. Basically, you mail it in or file it with the court. So all the work with guardianship is up front. Once you are the guardian, the process is not overly cumbersome, but that is the process. Let me see if I can get this to forward here. All right, there we go. So when is a conservatorship necessary? Remember, conservators when the court appoints somebody to handle the financial matters or business matters for an incapacitated adult. It's when the person has assets and there's no financial power of attorney or trust in place. You don't get to handle somebody else's financial matters just because you're related to them by blood or marriage. Unlike medical decision-making under the surrogate statute, you can, if there's no healthcare power of attorney or guardian, a parent can make decisions for their unmarried adult child, just like they can for their minor child. But let's say they do have a power of attorney, but they're mismanaging their assets. We need to protect them from their own mismanagement or exploitation by third parties. Or if the person who does have authority is misusing that authority, stealing, abusing the finances, or if third parties are exploiting. So, conservatorship might be necessary in a number of cases, but there has to be assets to conserve. Otherwise, we don't need it. So what else can you do to protect your child or your loved one who has a special need? You can get a guardianship in place if they're an adult, if you feel like that's necessary and would be in their best interest. You want to make sure you apply for all applicable public benefits, DDD, ALTEX, which is Arizona Long-Term Care Systems, SSI, Dependent Adult Child Benefits, which is a different Social Security benefit. You want to make sure you get your child plugged in. And I deal with families every day that say, we can financially support our child. We don't need SSI. We don't need, or my child is on my employer's health insurance benefits and they're covered to age 26. So we're not going to deal with access health insurance. That's usually a mistake. And here's why. You want to get your child plugged into all of the benefits at the earliest age possible. Many of the benefits programs like Social Security, certain, DDD services, you have to have medical records from when the child was a minor. Well, if you're not applying until this child is 35 for benefits, good luck getting the pediatric records. I'm telling you, they're not going to be around. And the parent usually knows what's going on. Well, in the event of an unforeseen circumstance, parent dies suddenly, and now you have the siblings or aunts, uncles, grandparents trying to pick up the pieces. They may not have all of the information to put the jigsaw puzzle together of the medical records if we need those records to apply for certain government benefits. So it's always better to do it sooner rather than later. Access health insurance is going to be a backup. It's secondary insurance to employer covered or private insurance. It's always good to have a backup. Why not? If they're not providing a benefit, fine. But if you lose your job, you need coverage for your kid all of a sudden, they already have it. ALTEX, Arizona Long-Term Care System. A lot of parents will say, oh, we're providing all the support and help at home. We don't want to deal with the ALTEX program. Well, what happens if the parent suddenly passes away or becomes ill and they're not able to be the caregiver? Now we're going to have months and months and months of application process to ALTEX. Well, who's providing the care and how's that getting financed during those application months? It's always better to get them plugged in sooner rather than later, even if you're not taking a huge advantage, just for advanced planning against incapacity. And then the other big area is planning for future inherited assets. And this is when estate planning with special needs loved ones is very different than traditional estate planning. And traditional estate planning is important for everyone, right? You need a power of attorney for yourself, because if you become incapacitated and you don't have one, you're going to be the subject of a conservatorship. And people don't realize that. That is probably what is going to happen. Your spouse, if you're married, doesn't get to deal with your retirement account or your 50% interest in your real estate just because you're married. I don't have any other tools in my toolkit. There's no other options. I have to go to court and get conservatorship. Nobody knew what conservatorship was until the hashtag Free Britney Spears movement a couple of years ago. So now I kind of joke, you don't want to be Britney, right? Simple power of attorney is the best way to keep you out of court if you're incapacitated. You need healthcare medical directives, right? If you're in an accident, can't make your own medical decisions, clear chain of command for you. Just like all this stuff we're talking about for your child, this is for every adult over the age of 18 needs good basic estate planning documents. But when we talk about testamentary planning, meaning for the next generation, how are we going to leave assets? You generally do not want to leave assets outright to a child with a disability or special needs who may not be able to manage that, because if they inherit a big chunk of money, even if they're not on means tested benefits like SSI or Altex, but if they can't manage the money, that's going to create the need for a conservatorship, right? We just put them in a court situation they probably didn't need. Court costs a lot of money. It's good to avoid if we can. I always joke, I'm a lawyer. I like going to court. My clients are not loving the experience. So if I can keep people out of court with good planning, that's what we want to do, right? It's there as a safety net, and it's a great tool when I need it, but I would rather plan to avoid it and keep everything private, less expensive. Generally the less lawyers involved, the better, right? I think everybody kind of agrees with that as a general principle. So, we plan for your own incapacity for medical decision-making, financial management. But then when we talk about the testamentary plans, what are the options for how you leave assets to someone with a disability or special needs, right? If they're not on means best tested benefits, but they can't manage money, you want to structure it in a trust for them. Or if they are on means tested benefits like SSI or Altex, you can't own more than $2,000 in countable assets, meaning checking, savings, brokerage, cash assets generally, and continue to qualify for SSI or Altex benefits. So you don't want them to lose their income or their long-term care benefits, which may be paying for their adult care home or their, help at home with their activities of daily living. So the other options then, and I've been going through the list here of what everybody needs, would be either a will with a testamentary special needs trust, or in most cases, a trust for you that owns your assets. It's a better vehicle for a lot of people to use for their personal estate planning, that after their passing creates what we call a testamentary, meaning it doesn't exist during their lifetime, special needs trust, or what we're going to call a supplemental care trust. So we're going to talk about what the goals of a special needs trust are, and then I'm going to unpack a little bit the types of trust to avoid any confusion. So the goal of a special needs trust is to enrich the life of its beneficiary, the person with a special need. It's also going to appoint a trustee to prudently manage the assets of the trust. The trustee will never be the beneficiary. It's always going to be somebody. The trustee could be a relative, a dear friend, but it could also be a professional like a licensed fiduciary or a bank and trust company. So lots of options for responsible trustees. The assets of the trust are not countable against the beneficiary for qualifying for means tested benefits. So in a special needs trust, you can have millions of dollars in a special needs trust and still qualify if you're the beneficiary for SSI, Altex, or other means tested benefits. I always like to say it's the one way they can have their cake and eat it too. So the trust can provide for all of the extras, while the public benefits are providing for all of the basics. And by keeping public benefits intact, the assets of the trust are going to last a lot longer over the lifetime of that beneficiary. The assets of a special needs trust also have creditor protection. So if your special needs beneficiary is the subject of a lawsuit, they're driving, they get in an accident, or for whatever reason, they're going to have creditor issues. They're bad with money. They take out a credit card, can't pay the bill. They need to file personal bankruptcy. Trust assets through the inheritance are protected against all of their creditor claims, including the claims of the government. There's no payback or reimbursement after their death to Medicaid or Social Security or Medicare or any government program. And we can also achieve some really tax efficient outcomes with the use of a special needs trust. So how do we create these things, right? They are written documents. So here's how you and your estate plan can create a special needs trust, or what I'm going to call a third-party special needs trust. You can have a revocable trust that after your death, embedded in it, creates what we call a testamentary special needs trust or a third-party special needs trust. You can also have a standalone third-party special needs trust, meaning you create this trust now during your lifetime. It is a thing, as my daughter likes to say. It is a legal entity. When would we do that? Oftentimes we do that when we have multiple members of a family that all want one vessel. They can all designate to receive lifetime gifts for this beneficiary or testamentary distributions. So, you know, I have a couple of cases right now. I have mom, dad, both sets of grandparents and siblings. And both sets of grandparents want to leave something for their disabled grandchild. A sibling who is an adult wants to leave something for their disabled sibling. And mom and dad want to leave a good percentage of their estate for a sibling. So rather than having 1, 2, 3, 4 trusts potentially ultimately set up for this one person, we have one trust, it's one pot, and everybody just names this one trust to receive monies. So it's an efficient way to do it. But most often it's just the parents or the grandparents who are like, I'm doing this. I don't know if anybody else wants to do this or nobody else will. So we just embed it and it is created after the person passes away. You could also create these trusts through a will. So whether you use a will or you use a trust will depend on what makes sense for your personal estate plan and your goals. Most people end up using a revocable trust that creates this third-party trust. All of these, when you are creating the document and it's your estate assets that are going right into this trust, the monies never belong to the disabled child or the special needs child, because the money belonged to you or a third party, not that child, and it went straight into a trust. So we call these third-party special needs trusts, and they're very flexible in their administration. A first-party special needs trust, or what you will commonly hear called a D4A trust, is very different. That is a trust that only a disabled individual under the age of 65 can use and put their own money into it. And it has to have a Medicaid payback provision. So we're going to talk about the distinctions and the circumstances. But a revocable trust that is created as part of your estate plan that after your death creates a special needs, or what I'm going to call this third-party supplemental care trust, it allows the assets to flow from parents, grandparents, or third parties right into this trust. You select the trustee. So you're going to name who is going to manage this trust for your special needs loved one. It gives them creditor protection, it gives them public benefits protections. It's all distributions of income or principal are within the sole discretion of the trustee. And if the beneficiary later passes and there's still money in the trust, there's no Medicaid payback. So it'll go on to other relatives or perhaps charity, whatever you want. You know, the government never gets a dime of it. You can create the exact same thing with a will. The big difference between using a will versus a trust is a will is probably going to end up in probate. So for many people who want to avoid a probate after their death, they will use a trust, because we can create the same trust, whether we do it from a will or a trust, but we have probate avoidance. And it's also a little bit better way to do it. If IRA monies are going to go, you would never want IRA monies to pay to the estate. It has to go directly into a trust. So IRAs are a whole other topic. The standalone third-party trust, that's the trust that exists now during your lifetime. Assets can come from any third party, so multiple relative, family, friends, exactly. Again, you choose the trustee. It'll have creditor protection. It usually becomes irrevocable depending on how we drive. It can be revocable during your lifetime, but it will become irrevocable if you pass away or if you get IRA monies. It's great for multiple contributors. It's fully discretionary. And again, there's no Medicaid payback, so it can go on for future generations, or again, for charities. There's no payback to the government. Very different rules on a first-party special needs trust. You would only use this first-party special needs trust. There's an unplanned inheritance or perhaps a settlement, like a lawsuit, your child's in a car accident or medical malpractice lawsuit. They're coming into sum of money. It is their money. It's not yours, it's theirs. And that will cause them to lose SSI, all text, or other means tested benefits. If they're disabled and under the age of 65, we would create a first party special needs trust. It's very unique, created under federal code. It's the emergency fix, so we can keep benefits in place, but there is a Medicaid payback. Access has to pre-approve distributions if they are on access or all text benefits. Likely that you're going to need a lawyer to help the trustee administer this because there's a lot of oversight with government agencies. It's more complicated on how you administer it. But you can choose the trustee, which is really great. This is a fantastic solution when we need it, but it's far better off for families to create the trusts that have a lot more flexibility, no Medicaid payback, and no pre-approval by access over how the money is going to be spent when the family does the planning ahead of time. So, how do you set up your estate plan? Do you use a will? Do you use a trust? It's really going to depend on the type of assets you own, your goals, your objectives, and your attorney. If you have a loved one with special needs, you should absolutely work with an attorney who is both an estate planning and a special needs planning attorney, because estate planning attorneys are not familiar with public benefits at the granular level, and they also don't represent the trustees in administering these types of trusts. So they don't have the experience in the real world to be able to draft these things that are going to function optimally in the real world. So I always say, you always want to work with a very experienced estate and special needs planning attorney, because they're going to be able to help you craft the best plan. And then when the plan goes into action, they're also going to be there. They will know you, they will know your objectives, they're going to be familiar with your family, and that's going to give some continuity to the implementation of the plan to work as best possible. So the trust assets can be used to supplement the needs. We can keep this beneficiary on public benefits. Maybe we need a successor guardian appointed. By the way, in your will, I don't know if you're aware, but you can designate in your will not only who a guardian would be if it's not you after your death for your minor children, but also an adult unmarried incapacitated child. So sometimes what happens is we'll have parents who don't feel the need to get guardianship because the doctors have a long history with them, etc. But they're very concerned if the parent passes, will the sibling get the same level of cooperation if the sibling would step in and now be the medical advocate and helping. So they may want to name the sibling or somebody else in the will as the legal guardian, because we have an expedited court process. We don't even usually need a hearing. If the parent names a guardian in their will for their adult incapacitated unmarried child. Always have to, it's hard to say all that together. So there's a lot of considerations in your own estate plan, naming of guardians under will, successor guardians under wills. Do you use a will? Do you use a trust? Who are the successor trustees over the trust for your children if you are going to use a supplemental care trust or a third-party special needs trust like we talked about? I often get asked the question, how often I set this up? I feel great. I threw it in my closet or in my lockbox. When do I need to pull it out and look at it again, right? We recommend a review every 3 years because family dynamics, your assets, and tax laws can change. So we want to make sure as life changes, your documents reflect those life changes. An outdated plan is not an optimal plan, and a plan can be outdated very quickly. So usually every 3 to 5 years is kind of my benchmark, unless you know you need to talk to your attorney sooner because there's been some change that you're aware of. Change in personal circumstance, marriages, deaths, divorces in families, moves between states, significant change in financial circumstance, or your named people have significant changes in their personal circumstances, are all kind of good hallmark, just keep in the back of your mind, oh, I should probably, something like that happens, I should probably have my attorney review my documents and make sure that they are still good. I have time for questions. I sped through it really quickly. I didn't necessarily see too much happening in the chat. I guess Shannon, you asked, did I say limited is most common? Actually, the full guardianship across the board is the most common type of guardianship we see. But when it comes to younger individuals who are developmentally disabled, we may see limited guardianships in those circumstances. But usually full guardianship is the most common type of guardianship. And Autism Society of Greater Phoenix did comment, the court prefers the least restrictive guardianship possible. 110% that's true. It's in the statute. That is what the lawyer should be consulting with you about in the initial meeting. You know, would your child want to be able to drive? Would they want to be able to vote? Can they make their own medical or living arrangement decisions or education? You know, where are your roadblocks and your concerns coming? Where do we need to get you over those roadblocks and bring solutions so that you're going to be able to do everything you need to do that your hands are a little tied for now or you're worried about. But the court, yeah, always wants the least restrictive arrangement possible. Other questions? We can talk about all kinds of things. I just sort of went through it really quickly, try to hit the highlights to give you guys ideas of, you know, when to start thinking about these issues, all the issues that you can spot, and just mostly so you know there's resources for you. A lot of times parents will get stuck if you don't have a large, fantastically equipped family that, you know, could be your successor guardian or could serve as trustee. A lot of times people get stuck and don't do everything. That's even more reason for you to talk to an experienced estate and special needs planning attorney so that they can give you referrals. There's licensed fiduciaries, there's bank and trust companies, there's professionals that can step in the gap when you don't have family, or you have family, but you don't want them in certain roles, because I see it happen both ways. Couple of good chat questions here. So Shannon says, what are some ways parents talk to their youth about guardianship? My recommendation is to approach it as a team. You know, when you're the parent of your child, you're a team. You're on their side. And you can talk to their teachers. You can go to the IEP meetings when they're 17 and younger. You can talk to their caseworker. You can schedule their doctor's appointments. And they like that team approach. You can explain to them that once they turn 18, you lose all of that authority. You really can't necessarily talk to their doctors as easily or help them as easily. Now, if they're able to understand medical directives and financial power of attorney, you probably, when they get close to 18, bring them in and talk to an experienced special needs estate planning attorney and have them do powers of attorney, right? So they can make decisions, but you're still able to be there in a supportive role and have them do a medical release, by the way, and also an educational release. Some school districts have their own. Sometimes you'll still get pushback from DDD or from Altex caseworkers, and you still have to go the guardianship route just to really be able to know you've got it all locked in. But we can help with that conversation. I generally just say, listen, I'm still mom, I'm still dad, or I'm still grandparent, and I want to be on your team. And in order for me to do that, I need a paper from the court. You know, you don't want to say, I'm stripping you of your civil liberties and you're not going to be able to make your own medical decision. You know, you don't want to say that. But I think that's kind of the best way to approach guardianship, is just to say, if I'm your guardian, I still get to act as your parent under the law, because literally that's what the statute says. The guardian has the authority a parent does over their minor child. So I would start with that. Michelle's got a good question. How do I even begin with this? It seems very daunting. What happens when maybe we don't have a guardian? So a great place to start, honestly, is probably just to have a conversation with a special needs planning attorney, because your situation is going to be different than the next family's situation. I always say, there's common themes in planning, but no one situation is the same as the next. So it's like snowflakes. They all look alike, but when you get them under the microscope, every single one has a different crystalline structure, right? So it's kind of the same thing with special needs planning. So you can read a lot. You can check out my website. We have a lot of resources, general information, but honestly, clear the fog. Just go in and do a consultation with an experienced special needs planning attorney, and they'll just tell you, okay, step 1, step 2, step 3, you're going to do this. You might want to do this. Here's what you need to think about. Here's additional resources if you need them, and kind of take out the fog for you. Because you can read and read and read, but if you don't know specifically related to your circumstance what might be best, you're still going to feel really overwhelmed. That's at least my experience. What happens if you don't have a guardian? Okay, without a guardian, if you are a parent, you are still what's called the surrogate medical decision maker. So if your child is unable to make or communicate their own medical decisions and they hit 18, if you're working with a cooperative doctor, you're going to be able to make their medical decisions, because the doctor is going to determine your child is not able, that there's no healthcare power of attorney. Then we have a default statute called the surrogate medical decision maker statute that is going to allow you to be the decision maker. And sometimes parents, that'll work, other circumstances, your child ends up in the hospital. Now we've got medical providers that are not familiar with your child or you. Sometimes it gets a little nerve-wracking for parents until they can explain the whole situation, and maybe a guardianship would be better, but theoretically you could make the decisions. There may arise a circumstance in the future where you would have wanted guardianship, but I have cases where parents didn't do guardianship of their children, and now the parent is 70 years old and the child's in their 40s, and for the first time they're having issues and we need to get guardianship. It's hard to predict, really. And again, I think that's why it's a case-by-case situation. Shannon, yeah, I'm just so afraid of people taking advantage of my son who has autism, making all these tough decisions without seeing all the moving parts and consequences. Exactly. That's where guardianship puts you in the driver's seat. If you're the legal guardian, your son legally cannot consent to medical treatment. It has to be you. And everybody knows it in the medical system, from primary care doc to the podiatrist, to the dentist, to the hospital, to the surgeon, all the way along. Same thing with DDD, all text caseworkers. They're going to know they have to deal with you and not your son. And you don't get iced out of those conversations. So really guardianship is the best way. And then certainly in your own estate planning, we want to plan for your incapacity or your passing as a parent and make sure that your child is going to be protected and that his inheritance is going to be managed appropriately by somebody like, and trust, right? We don't want to leave that to chance. So whether that's going to be a third-party professional or a relative or a best friend who knows your son and his situation, you can plug in, all of those moving parts as best possible ahead of time. And that's what advanced planning is, right? It's thinking about guardianship. Does it make sense? Doesn't it make sense? Plugging them into all the public benefits we can now. I like to say, I don't want to leave money on the table. If we can get money, we can get benefits. Let's do it. It's easier now when they're younger than when they're older or after you pass. Because again, people aren't going to understand all the moving parts, and then making sure your estate plan is in good shape and talking to your family. I have parents who will then talk to the grandparents and say, hey, please don't leave little Jack or little Sarah, which are my kids' names. Don't leave little Jack or little Sarah money outright because they're going to lose their SSI, and then we're going to have to do a first party special needs trust with oversight by the government and a Medicaid payback. It'd be better if we planned ahead and we did it another way. And, we can confer with the family. A lot of times for parents, we'll create that standalone trust and give the parent a standardized letter they can send to any friend or relative they want, who they think might want to leave something for their child in their estate plan or holiday gifts or birthday gifts, and say, if you're considering making a gift or a bequest in your either during your lifetime or thereafter for my child, please consider designating this trust to receive it, because they'll be able to keep their benefits, etc. All of the positives. So those are all the concerns. Good question. How hard is it to get guardianship? Okay. Worst answer from a lawyer ever is it depends. Okay. If nobody's arguing, right? We don't have an emergency. We're not in a life and death circumstance. So we're not running around like mad for 48 to 36 hours trying to get the doctor's forms and the pleadings and everything. That's not that stressful. So we have no emergency and nobody's disputing. There's no dispute among the family about whether whoever is asking to be guardian would be good or would be in the best interest. And the child is not objecting. It's not that hard. It's a paperwork process, and there's a lot of protocol to follow. There's something like 8 different pleadings that have to be completed. Notice has to be given pursuant to statute. It's like check the box on all the procedures. But once you do that and you're in court, the doctor's evidence gets admitted, nobody's objecting, you give simple testimony, you should leave within 48 hours. You should have letters of appointment in hand from the court. So it's an exacting process with the right pleadings and the language and the forms and the process. But if nobody's arguing, it's not a difficult court proceeding to go through. Where it becomes difficult is when people are arguing. Your child objects, right? Now we have a contested proceeding. Another family member objects, one parent, a divorce situation. One parent wants to be the sole guardian, the other parent wants to be the sole guardian, but they have co-parenting time from a previous court order, family dissolution agreement or something, or for whatever reason, somebody wants to do the job over you, then that's when it gets a little more difficult and a little sticky with the family, and we have to litigate. We need the guardianship. Medically, this person is not able to make appropriate and reasonable decisions for themselves. They're in need of guardian. And then we litigate. If that's not the issue we're litigating, then we're litigating who will be serving the best interest. So absent that, it's not that terrible of a process. As with any court proceeding, technically you do not have to have a lawyer. Maricopa County has self-help forms in the probate section. If you go on to Maricopa County Superior Court, they do have instructions with fill in the blank forms and instructions. I do know some families will do it on their own. A lot of families, however, will hire a law firm like ours or another to have an attorney get them through the process, because it is a pretty exacting process, and it just gives you that peace of mind that you're not going to get, stuck at some point in the process and having to go back to hearing and all of that. If your child is on public benefits and does not have significant savings or assets, you can ask the court to determine the child is indigent. We do this all the time, so that it waives the court filing fees. The court charges almost $600 just to file this with the court, just to start a guardianship proceeding. But you can ask the court to determine to waive the fees to get the matter initiated. And then at the hearing, you confirm that, what the income and the assets are of the child, and then the court will waive the filing fees. So that's a nice little trick most people don't know about to shave some money off. Question, what do we charge? It's always a good question. It depends. Most attorneys will charge by the hour. For a non-emergency, uncontested proceeding, Probably hourly, it's going to be anywhere from $3,000 to $5,000, maybe hourly. For a lot of our clients, if it is an 18-year-old, I call them the kid case. You know, we have someone with a developmental disability, they're a young adult, 18, 19, 20. The parent is now finding the need and moving forward and doing guardianship, and we don't think it's going to be objected to. We may quote a lower flat fee, and as long as it doesn't become contested or litigated, it won't move on to an hourly basis. And so a lot of times what we'll do is, I've already done the estate plan for the parents or the grandparents and created the trust, etc. And so we'll charge for the estate planning, and then I'll do a discounted flat fee just to kind of throw that in the mix for the guardianship. And that might be like $2,500 on a discounted flat fee. Every case is a little bit different, but that should at least give you an idea of the range. And I think that's pretty consistent with most law firms. The court is used to seeing hourly fees, so a lot of attorneys will charge hourly, but sometimes if we know what we're in for, we can get a reasonable flat fee and discount it just to be helpful, and then try to get the court to waive the filing fees to save that $600-700 to the family. And then when the child is determined to be indigent, the lawyer that is appointed for the child by the court will be paid by the court. So the legal fees of the family or the petitioning party is just their lawyer's fees, not their child's attorney, and not the court costs if we can get the indigency order approved. And that's usually the case with young adults is, you know, unless they have a settlement coming in or something like that, they don't have enough money to pay the fees. And so the parent doesn't have to, which is nice, the filing fees, or I'll say filing costs. Does that help? I know it depends is just the worst answer ever from a lawyer when it's like, how much is this going to cost me? You know, it depends is not very reassuring. Oh yeah, listening in the car. No, it's not $3,000 to $5,000 per hour. It's usually $300 to $500 per hour total cost from beginning to end of a guardianship proceeding where there's no emergency or no objection. No, it's not litigated or contested. Usually between $3,000 to $5,000 total out of pocket in attorney's fees. When it's on an hourly basis. So yeah, no, I do bill at $500 an hour, not 5,000. So, but 500 is a lot. So usually when we're doing all of this planning for a family, we try to do flat fees so that the family has some financial certainty as to what the costs are going to be anytime we can, particularly on a young adult case. In cases where we're dealing with somebody where, you know, we have somebody who's in their 40s or their 50s, and now we're doing a guardianship and they have a lot of assets they accumulated prior to guardianship, or there's more complicated life issues going on. Oftentimes, it's hard to predict how much work is going to go into that case because there might be more variables at play, more relatives at play, etc. And so that might be an hourly type case. So hopefully that helps. You guys have had really good questions.
Those were really great questions. It's a good refresher for me too. So I know some questions that we've gotten because within our Autism 101 class, we just very much poke our toe in the waters and end up saying, there's all these other people that you need to talk to besides us because we're not specialized in this. But I know some questions that we've gotten before are like, if somebody has a special needs trust that already is funded, can they use funding from that to then do the guardianship process?
I will say yes, with an asterisk. It will the real answer will depend on the language in the trust with regard to what are the permissible purposes for which distributions can be made. I have never seen a special needs trust where we are not able to use, whether it's a first party or a third party, where we are not able to use the money in the trust to support all of the legal fees and costs related to guardianship. But, I always have to read the trust to make sure.
Right. Okay.
Yeah. Yeah. And a lot of times what will happen is people will have these old trusts and they're not optimal and they'll be funded with a little bit of money. And so we're like, okay, let's use that trust to pay for the cost of creating the new, more flexible, modern trust, the guardianship. Like, it's not ideal the way it was structured. There's not a whole lot of money in it. So let's drain it, come up with a better plan. For people who have like these really old plans, we definitely want to look and see everything. Sometimes parents get super excited and they created an old third-party trust. It's irrevocable. It didn't need to be irrevocable. It's got some money in it. Then they funded an ABLE account and they overly funded an ABLE account because they got excited about that and didn't realize there's a Medicaid payback. And then maybe grandma left some money and there's a third-party trust from grandma that held, some money there. So it's like we have to look at all the buckets of money and decide where's the best one to pull from if we have these other sources besides mom and dad's checking account.
Right. And I would say, just point out too, that's the benefit of doing the special needs trust is it doesn't have caps like it does the ABLE accounts.
Correct. Yeah, exactly. And you can coordinate. What's really great is you can have a third-party special needs trust that, let's say, like grandma's estate planner, mom and dad, and grandma put money in, and the parent is still the custodian on an ABLE account. So we've got a chunk of money in the special needs trust, this third-party special needs trust. We have an ABLE account, and there's some money in the ABLE account, or maybe we want to use an ABLE account. We can take money from the trust, fund an ABLE account. When you use money from the ABLE account to pay for shelter expenses, you don't have the 1/3 reduction in the SSI benefit that you otherwise have when a third party, like a parent or a trust, pays for shelter expenses. So there's some really cool things we can do in how we administer and which bucket of money we're using to pay certain types of expenses from to maximize all the public and the other cash assets available. But that's why working with a special needs planning attorney is very different from working with a general estate planning attorney, because special needs planning attorneys are going to get into the granular level. Like, I'm going to be asking questions like, what's the budget? How much money are you using for your child? What are those purposes? Okay, here's how the trust would work. Do we want an ABLE account? We're going to figure out what are the tools that you want, because sometimes parents get super excited and they're like, oh, there's all these things we can do, but you don't need them now, or it doesn't make sense. Like, why fund an ABLE account as a parent if you don't have to? That's going to have a Medicaid payback. You're still a parent. You can buy extra therapies and pay for transportation or, recreational, activities or hobbies for your child as a parent and pay a third party directly. We don't need it in an ABLE account that if your child passes, unfortunately, you lost your money because it'll go back to Medicaid. I mean, people just don't realize all the options. Mm-hmm. So I think that's where, kind of back to one of the other questions, like, this seems overwhelming. I get it. It is. It is completely overwhelming. And from a day-to-day experience, let's be honest. When you have a child who has special needs, you're their parent forever. You have extra time requirements. You have extra emotional drain. You have all of the, parenting, advocacy, medical decision-making, educational. You have all these other things you're worried about. And so to become an expert overnight and all of this highly technical stuff, it is overwhelming. That's why there's professionals that can help you. You don't have to become an expert overnight. in everything. Your job is to know what is important to you, what your child needs, what your goals are. And then the professional is going to work with you in helping you create the plan and navigate and walk that path with you, with your child. That's our job. Your job is to know what you want, like big picture. Our job is to extract enough information out of you to say, okay, here's how we're going to make big picture happen. But at the granular level, here's why. Does that make sense? Yeah. So it's, it's like a jigsaw puzzle. It's putting it all together. There's themes for everybody. There's the rules, there's the benefits, there's how things work. But then there's your family, right? And all the personal circumstances that go into that plan. So I don't know, what other good questions do you get at the Autism Society? I'm curious.
I think you pretty much covered everything. I mean, that was because a lot of people are, like you said, are really concerned about, they don't want to hit that, that $2,000 mark to not even initially to start qualifying for services, or, even as you have aging grandparents, like these are things that, a lot of families, especially within our Autism 101, they're newly diagnosed.
Yeah.
And these aren't things that anybody goes over at diagnosis time, right? So it's good to have that information. And like I said, we're always referring out to you guys, just so that other people can have that information. Because like I said, we only kind of tiptoe a little bit, because obviously, like you said, it was a perfect analogy to say that it's like a puzzle, because in a sense, it's like the family's putting together the border and you guys are putting in all the other stuff in there to make it a puzzle.
Yeah. Yeah. That's really good. I didn't think about the puzzle with the logo for autism, but yeah, when I said it, but yes, absolutely. So
yeah, well, thank you so much. I mean, that just was a really great source of information. So I really appreciate that you spent your time with us tonight. I really appreciate it.